Hi, everyone. Thank you for joining our Know Your Employment Rights workshop. And it's being presented by the Solar Multifamily Affordable Housing Program. And today is December 16th, 2021. So for today's workshop, I'll be moderating and introducing our presenters. My name is Ingrid Murillo. I'm the SOMAH Workforce Development Coordinator for the SOMAH Program Administration team. And we're going to have great presenters, Yonathan Rodriguez from the Deputy Labor Commissioner from the Department of Industrial Relations, and Branden Butler, Assistant Deputy Director of Education and Outreach at the California Department of Fair Employment and Housing. And we're going to save at least 10 minutes at the end of the presentation for questions and answers. So today's topics, we will be covering the following topics: your right to a harassment-free working environment, free of retaliation, minimum wage and overtime standards, your right to meal and rest periods, and how to file labor complaints with the Department of Fair Employment and Housing and the Department of Industrial Relations. And there are plenty of other regulations and other topics that protect employees in California, such as safety regulations on solar installation job sites. We will not have time to cover everything today, but SOMAH will continue to host webinars and workshops on relevant topics for job seekers, including safety information in 2022. And sign up for the SOMAH email list to stay updated on events and webinars. And we'll chat the link later for that to sign up. Although everyone is currently muted by default, we have many ways you can interact with the speakers and share your thoughts and questions throughout the webinar using the buttons at the bottom of your Zoom webinar screen. You can submit questions anytime using the Q&A button. Type in your question and we will do our best to answer as many questions during the Q&A portion at the end of the webinar as possible. You can also share a thought or comment using the chat feature. You can either chat directly to the panelists or to all panelists and attendees. Please be respectful with your comments during the Q&A session. You can also choose to use the raise hand feature if you would like to be taken off mute to ask your question verbally. So for today's poll question, we're going to send a poll out, and that question is, why is it important to know your employment rights? So Stacy, let me know if you need help with that. Oh, sorry, that's up already. So you can just click on the answer that you feel is correct, and then when we get all the answers, we're going to send the results. Thank you. And everyone said all of the above. So yeah, why is it important to know your employment rights? It's important so you can feel confident and safe in any job. Understand an employer's responsibility to every employee, advocate for yourself and your colleagues, and know where and how to report any violations of labor laws and how to hold bad actors accountable. So yeah, these are the reasons why SOMAH is hosting this webinar. We feel it's important to empower job seekers and job trainees that participate on SOMAH projects with knowledge and awareness of their rights as an employee. And we hope that sharing this information will help job seekers feel confident on any job site and, understand an employer's responsibility to every employee, advocate for themselves and their colleagues, and know how to report violations. So why is this important? I'd like to share a personal story. When I was in college, I had a part-time summer retail job. I witnessed some glaring California employment law violations, and managers and supervisors asked staff to work overtime, but asked us not to report it in our timesheet. And at the time I was going to college and I had some knowledge of California law because of my political science class. And when a manager asked me to clock out but stay working, I let him know that that was illegal and I wouldn't do it. And I told several coworkers that they're not allowed to do that. And after I left, my coworkers sued the retailer for wage violations. So I think this is something that impacts a lot of people, and especially, you know, in retail and minimum wage jobs. And next, Jonathan will be discussing wage standards, meal and rest breaks, and how to file complaints with the Department of Industrial Relations. Jonathan Rodriguez is the Deputy Labor Commissioner at the California Department of Industrial Relations. He's been with the department for a few years. Before that, he was enrolled at California State Bakersfield, where he obtained a BS in business with an emphasis in human resources. Take it away, Jonathan.
Thank you, Ingrid. So again, my name is Yonathan Rodriguez. I am a Deputy Labor Commissioner for the Labor Commissioner's Office. I'm here to talk to you today about some of the typical issues for non-exempt employees in California. You know, we'll go into some of the basics. I will direct you if you have any additional questions or something that's more complex than what I'm going to cover today, to visit our website or our offices to talk to one of the public information deputies. Next slide, please. And I want to share this welcome message from the State Labor Commissioner, Lilia Garcia Brower, and some information from her. So Lilia Garcia Brower was appointed by Governor Newsom as California State Labor Commissioner on July 29, 2019. As Labor Commissioner, she oversees a primary law enforcement agency for workplace protections. The Labor Commission has 19 offices throughout California and employs over 700 public servants, just like myself, who investigate and adjudicate a wide range of workplace violations, from unpaid wages to retaliation. Prior to her appointment, she was Executive Director of the Maintenance Cooperation Trust Fund for 19 years. Working with a powerful team of committed individuals, Lilia directed the MFTC as it grew to be one of the state's most effective joint labor management organizations. So we have a very strong leader and very knowledgeable in enforcing labor laws, and not just that, but just educating employees and employers throughout California. Next slide, please. I do want to share a disclaimer because the information that I'm going to be providing today is for general information only. None of the information provided here should be interpreted as providing legal advice or as a separate attorney-client relationship. Applicability of the information discussed may differ in individual situations. You should not act on the information presented here without consulting an attorney about your particular situation. Next slide, please. I also want to share the Labor Commissioner's mission statement. The mission of the California Labor Commissioner's Office is to ensure a just day's pay in every workplace in the state and to promote economic justice through robust enforcement of labor laws. By combating wage theft, protecting workers from retaliation, and educating the public, we put earned wages into workers' pockets and help level the playing field for law-abiding employers. Our office is also known as Division of Labor Standards Enforcement, DLSE. Some folks call it the Labor Board. Please don't confuse it with Department of Labor. That's a federal agency. Next slide, please. So this is the website I was referring to. If you have any questions or want to follow up on some of the information that I'm going to present today, this is a great resource. The Labor Commissioner's Office website, it's sort of a sub-website within the Department of Industrial Relations website. Once you reach the Department of Industrial Relations website, up at the top left corner, you'll see the Labor Law tab. You click on that tab and it'll direct you over to this website. It has information regarding the minimum wage schedule, overtime, your rights as an employee, and obligations for employers. So as an employee, one of the reasons you might look up the employer's obligation is to educate your employer, to let them know that, you know, what they're doing might not be correct or it's against the law. A lot of times employers don't know all the, you know, all the laws, so they act on what they believe is to be right. So it's a good way to educate your employer. A lot of resources, frequently asked questions. So again, just if you have any follow-up questions from today or a different topic, this is a good resource. Our offices are open to the public with limited hours. You can look up the closest office nearest to you and the hours of operations if you wish to visit one of our offices. Next slide, please. So all workers in California have rights. Workers in California have the right to file a wage claim when their employers do not pay them the wages or benefits they're owed. A wage claim starts the process to collect on those unpaid wages or benefits. California's labor laws protect all workers regardless of immigration status. So if you are working in California, you are protected on the California rights regardless of where your employer has their corporate office or where they mainly work out of. So as long as you perform work in California, you're protected under California laws. Next slide, please. So, and the Labor Commissioner defines wages under Labor Code Section 200 as wages including all amounts for labor performed by employees of every description, whether the amount is fixed or ascertained by a standard of time. So if you're working on an hourly basis, a task, if you're being paid upon completion of a task, upon completion of a piece, you know, you're putting together pieces and being paid per piece. A commission basis, usually based on earning a percentage of an item or service that you sell, or any other method of calculation. Some of the other methods can include on a per day basis. It's very rare, but it does come up from time to time. Next slide, please. So non-exempt employees and the overtime requirements. So what is a non-exempt employee? A non-exempt employee is someone who is not exempt from overtime. Not exempt means that you have the right to be paid for any hours that you work overtime. This is usually for employees who are paid on an hourly basis, not as salary. But if your employer does classify your pay as salary, it doesn't mean that you're automatically exempt from overtime. That's just how they want to set up your pay. Most exceptions for overtime are found in the Industrial Welfare Commission orders and include salary and duties tests. So in order for you to be truly exempt, you have to meet a minimum salary, which is 2 times the state minimum wage for up to 40 hours of work per week. And you have to meet all of the duties tests. Usually the duties tests include some type of a position in the company where you're an executive, an administrator, or some type of a professional exemption where you need to have a license or certification from the state. So if you're just a general employee, general labor, and you're reporting to somebody on a daily basis, they tell you what duties you're going to be doing, you're most likely not an exempt employee. So when you do not meet the exemptions, you have to be paid overtime and double time correctly. So overtime is 1.5 times your regular rate of pay for all hours worked in excess of 8 hours and up to 12 hours in a work day. And for the first 8 hours on the 7th consecutive day of work in the work week. So this is the general rule. 8 hours in a day is your regular rate of pay. After 8 hours is overtime, up to 12. There are some exceptions in certain industries, so just make sure to look that up if you have any doubt or questions. So it does talk about the work day. A work day is 24 hours. If your employer has not provided an established work day, it will default back to midnight of For example, midnight of today up to 11:59 p.m. of today. Once it's midnight of the next day, you're going into a new work day. So if you're working past midnight, those hours that you worked in the next day are not necessarily going to count towards overtime. You're starting over as you're starting the new day. You also have to be paid double time, and this would be double your regular rate of pay for all hours worked, in excess of 12 hours in any work day, and for all hours worked in excess of 8 hours on the 7th consecutive day of work in a work week. So when you are working on a daily basis, if your employer has not set up an established work week, the work week is going to be default back to Sunday at midnight to Saturday 11:59 p.m. Okay, so 7 consecutive days in a work week would be working Sunday through Saturday in that week. If you work additional consecutive days, it doesn't mean that you're still accruing or that you should still be paid overtime, double time for the consecutive days. You're going into a new work week, so you would the same way that you started back from 0 hours going into the new day, this would be also true going into the new week. So again, there are some exemptions to the general rule, specifically overtime for agricultural workers. That's one of the most common exemptions. There is a schedule posted on our website. If you are working in the agricultural industry or know somebody who works in the agricultural industry, refer back to our website for the schedule. And I say this because we are coming into a new year, so things are there's some changes coming. Next slide, please. So pay days and pay periods. Your employer is required to have regular pay days, and this is governed under Labor Code Section 204. So regular pay days means that your employer has to notify you ahead of time when pay days are. They can set it up weekly, bi-weekly, semi-monthly, daily if they want, or more often, but it cannot be less than twice per month as long as you're a non-exempt employee. So twice per month can be, for example, like the 5th and the 20th of every month. And there are some exceptions to being paid timely. If, for example, the 5th landed on a Saturday or Sunday or a holiday, and your employer is not open during those days, then the employer has until the next business day to pay your final check. Usually employers will try to pay you ahead of time, but they're not required to. They're also required to post a notice of the pay day or the method under Labor Code Section 207. If they're going to change the pay periods, which often happens with the change of a payroll system, they have to notify employees before the change takes place. That way it gives employees a notice ahead of time. And there are penalties for the employer's failure to pay wages timely under Labor Code Section 210. This Labor Code is fairly new, but it is now available to claimants who file wage claims through our process. The initial violation is $100, and any subsequent violations are $200 each plus 25% of your payroll. This is during the time of your employment. So the first violation is essentially going to happen when you first make the complaint. Any subsequent violations are, second complaint, third complaint, and so on. Next slide, please. And here's a schedule for California minimum wage. Highlighted is the current rate of pay for the year of 2021. Employers with 25 employees or less, it is currently $13 an hour. Employers with 26 employees or more, it's going to be $14 an hour. We're just a few weeks away from the new year. The beginning January 1st, 2022, it's going to increase $1 respectively. And then the following year, January 1st, 2023, the smaller employers are going to level with the $15 an hour. So starting January 1st, 2023, all employees in California need to be paid at least minimum wage. We don't have any other schedules. If there's any other changes, our website is going to be a great place to look for any new schedules. Next slide, please. So with the state minimum wage, there are also certain counties and cities that have their own minimum wage. This is called the minimum wage ordinance. So certain cities and counties throughout the state have higher minimum wage, and this is generally to offset the cost of living. So you're generally going to find these in areas where population is highly concentrated, like LA, San Diego areas, up in the Bay Area. The list on here is just a sample list. It's not the complete list. So if you are working outside of where you live, it's best to look this up. A general Google search will provide you some information. And if there is some indication that the county or city where you're working has a higher minimum wage, you can contact the county or the city to confirm what you found on Google. So it's a good way to confirm that. Next slide, please. Some of the typical issues for non-exempt employees is minimum wage. So all employees in California have to be paid minimum wage for all hours worked. There is one tiny exception. It's called the learner's rate. And for the learner's rate, for the first 160 hours of employment in occupations in which the employee has no previous or similar or related experience, they may be paid in no less than 85% of the minimum wage up to the 160 hours, or until they learn the duties or the position that they're in. But just because they start off at a learner rate, it doesn't mean that they have to be paid the 160 hours. It's just up until the employee learns the duties for that position. Once they do, they cannot be paid the learner's rate anymore. Split shift differentials. A split shift is where a work schedule is interrupted by a non-paid, non-working period established by the employer, other than a bona fide rest or meal period. When an employee works a split shift, 1 hour's pay at the minimum wage shall be paid in addition to the minimum wage required for that day, except when the employer resides at the place of employment. This is generally mostly seen in the restaurant industry. For example, a restaurant opens for breakfast for a couple hours in the morning, and then they'll close. They'll close the business down. They'll reopen again for dinner. The employee were to work the morning shift and the afternoon shift. This is where that split shift differential comes in. That employee would have to be paid 1 additional hour at minimum wage per day. Okay. The exception when an employee resides at the place of employment, it's not very often that the employee resides at the place of employment, but it does happen from time to time. Usually we mainly see this in agricultural industry where the employer provides housing for the employee. That would be one of the exceptions. Reporting time pay under the Industrial Welfare Commission Order Section 5. If an employee is required to report to work and does report to work, but is not put to work or is furnished less than half of the usual or scheduled days work, the employee shall be paid for half the usual or scheduled days work, no less than 2 hours, no more than 4. So just an example is you're scheduled to work 8 hours, you show up, it's a slow day, you've only worked 2 hours, your employer sends you home, you've already worked 2, so the employer is required to pay you for an additional 2 hours to make up the 4 hours, okay? If you're scheduled for 3 hours and you show up and the employer sends you home right away, half of 3 would be 1.5, but the minimum that the employer is required to pay you is 2. So the same is true as if you have a 10-hour shift, you're sent home earlier, they're only required to pay you up to 4. And with the reporting time pay, there are some exceptions when the employer is not required to pay you. Those exceptions are pretty extreme. It's generally when the employer has no control over putting you to work. So it's called usually they have an act of God, an act of God, or something that the employer cannot control. Next slide, please. Continuing with some of the issues for non-exempt employees, de minimis time and rounding. Okay, so California law calls for all time work to be compensated, while FLSA allows for de minimis time not to be compensated. De minimis time refers to the couple seconds, couple minutes there, here and there, where you're not compensated for that time because the nature of your work does not put you to work right away. One example that I can think of with this is there are certain industries where employees have to come into work. Usually they have a locker or a changing room where they have to change into like a uniform or put on some personal protective equipment. So during that time, they're not working, they're not producing anything for the employer. But that time, because the employer is requiring them to do this, they have to be compensated for that time. So even though they're taking a minute, 2 minutes to, put on gloves, a helmet, things here and there, it has to be paid because now they're doing that because of the nature of the work. So California Supreme Court Troster versus Starbucks of 2019 ruled that no such regulation allowing de minimis time not to be compensated existed under California law. So basically all time has to be paid. Similarly, rounding or the act of approximating time work has been disfavored by California, and whatever loophole may exist after Troster and its progeny is extremely narrow. So we always caution employers who use rounding practices. Rounding practices are, where generally you clock in, and if you clock in, for example, 7 minutes after your scheduled shift was over, it'll round it back to the nearest 15. If you clock in or if you clock out 8 minutes after, then it'll round up to 15. The reason why this is, we caution employers on using this is because if the practice mainly favors the employer, now, all those minutes that accrue over a week, over a month, and over years add up pretty fast. And that's essentially time that the employer worked and they're not being paid. So we are currently waiting on a Supreme Court decision on rounding. It's the Donahue versus AMN Services LLC case. Once there's a decision made, we may need to adapt our practices and our enforcement. Next slide, please. So authorized deductions, these are deductions that your employer is authorized to deduct from your paycheck. This is under Labor Code Section 224. So any taxes, generally you don't have a say on paying taxes. Your employer is going to deduct the taxes necessary and required by law. Healthcare contributions authorized in writing. This is generally if you sign up for health benefits, 401k benefits, things like that. You've authorized the employer to deduct, so they will deduct that. Garnishments like child support, if you have wage garnishment on your check, the employer has to deduct that from your check. You really have no say in that. So that would be lawful, and it is authorized. Any additional deductions that are made without your authorization, those would be unlawful deductions. You can file a claim with our office and report the unlawful activity. Next slide, please. Itemized wage statements, also known as pay stubs, under Labor Code Section 226A. The employer is required to provide you a pay stub with each pay statement, with each check or payment that is made to you. A lot of times, employees who have a direct deposit, they won't be provided an itemized deduction statement, but the employer will give them access to the payroll system, and they'll be able to download them. That's completely fine. Or the employer mails their pay stub. Again, that is acceptable. There are requirements. There's a list of things that need to be on your itemized deduction statement in order for it to be a lawful itemized wage statement. There's a sample here in the next slide or two. That way I will review what information needs to be on there. If your employer is a farm labor contractor, they must also include the name and address of the legal entity that secured the services of the farm labor contractor. This would be the name of the farmer, the name of the grower, the name of the entity that hired the farm labor contractor. So under Labor Code Section 226.2, the total number of hours and rest, total number of hours of compensable rest and recovery periods, the rate of compensation, and the gross wages for those periods during the pay period must be included, except for employers paying compensation for other non-productive time and the total hours of other non-productive time. The rate of compensation and the gross wages for that time during the pay period must be included. There are penalties that the Labor Commissioner's Office can assess if the employer is not complying with the requirements. Initial violation is $250 per employee per violation. Any subsequent violations are subject to $1,000 per employee per violation. These penalties are civil penalties, meaning that these amounts would go to the state, not the employee. Next slide. Okay, so here's an example of how a pay stub or itemized deduction statement needs to look, or at least some of the things that need to be on there. So up the top left corner, Smith and Company Inc., that is the legal entity that employed you. That's the legal entity that's paying you. Your full name, last four of your social security number, or a separate employee identification number. Your rate of pay, including your regular rate of pay, overtime, double time if they apply, the pay period in which you're receiving the paycheck for, the hours that you worked, both for, again, regular, overtime, double time if applicable, all the deductions that were made to your check, the gross earnings, the net earnings, and also the sick leave hours that are available to you. Note that the sick leave hours don't necessarily need to be on the pay stub, but they need to be, it needs to be provided to you along with every pay stub. So we always recommend employers to have it on the pay stub. That way there's no additional documents printed, and it's just easier to reference, you know, when anybody needs to look up at the sick leave balance. Next slide, please. So here's another sample of a pay stub. All the things that were on the previous one are on this one as well, but the only difference of this one is if you're being paid on a piece rate basis. Underneath the employee name is the piece rates. So the rate per each piece that was produced during that pay period, the number of pieces corresponding to each of the rates of pay, and the total amounts. So if you look at right below that, they also have to have the number of hours that they work per that week. This is to ensure that the employee made at least minimum wage for the hours worked. If that employee had made less than minimum wage, the employer then has to default to paying minimum wage for the 40 hours. So that's why it's important to note that the hours are also going to be on the pay stub. Next slide, please. So reimbursement of business expenses under Labor Code Section 2802. Mileage, so 2021 mileage rate is 56 cents per mile. Don't confuse this with your commuting time. Commuting time is the time that it takes you to get from your home to your place of work and back home. That's not compensable time, that it's not mileage. You cannot claim that as a business expense. Business expense refers to, for example, if you're using a vehicle for work, the time that it takes for you to get from your home to your place of work, again, it's not compensable. Once you reach your place of work and you need to travel from that point on, then the miles driven from that point on until you get back to that point again, those are the miles that it's referring to. Again, driving back home is not something you would be able to claim. Anytime that you have to pass through a toll booth, or pay for parking, as long as it's within the course of business, then you can claim that as a business expense. Again, if you're having to go through a toll or park your car in order to get to your job, you cannot claim that. Reimbursement for meals, this is something where an employer would usually send you out overnight, and essentially meals are not provided to you. They would have to reimburse you up to a certain amount. Your vehicle insurance, if they require you to have additional insurance than what you already have, and any uniforms and equipment. Next slide, please. So meal and rest period. So anytime that you work for an employer, the employer is required to provide you a 30-minute meal period and two 10-minute rest breaks on an 8-hour shift. And this is just an example. So when you work 8 hours, generally after 2 hours, you're to receive a 10-hour or a 10-minute rest break. After another 2 hours or so, you receive a 30-minute meal period that is unpaid. You come back from lunch, work another 2. Generally, you get another 10-minute rest break. So it's supposed to be in between each of those periods or as close to that as possible. If your employer fails to provide you a 30-minute meal period, or they fail to provide it to you within the 5 hours, then your employer is required to pay you 1 hour of pay at your regular rate of pay. And then the same would be true for missing a rest period for that day. Your meal period has to be duty-free. So those 30 minutes, you're able to do whatever it is that you want to do, leave the facility, stay in the facility, whatever you want. The 10-minute rest breaks, again, that's also true for those 10-minute rest breaks. If that isn't the case, then there is a violation of the meal and rest period policies, and they have to compensate you accordingly. If they don't, this is one of the things that you can file a wage claim in our office to recover the premiums for each corresponding issue. Next slide, please. All right, so issues at separation. If you're discharged, if you're terminated, or if you quit, so under Labor Code Section 201, if your employer terminates you, all wages due are due immediately. Under Labor Code Section 202, if you resign without a notice, or you resign and give notice, the employer has 72 hours from the date of the notice. If your employer does not comply with either Labor Code Section 201 or 202, Labor Code Section 203 will assess penalties. If you file a wage claim, we'll calculate the waiting time penalties based on your daily rate of pay and however many days you waited until you received all of your wages. So final wages include all wages due, so anything and everything that you worked, including your vacation under Labor Code Section 227.3. And again, just to reiterate, the late payment of penalties under Labor Code Section 210, this applies when you are employed. Next slide, please.
Jonathan, we're running low on time, so maybe we can cover the next couple slides and then
yeah, but I believe I have one last slide.
Okay, great.
All right, so the vacation, just quickly, vacation, if your employer does not offer vacation, they're not required by law to provide a vacation. But if they do, they have to pay it out to you, either during the course of your employment or at termination or separation of employment. Just a quick example, if your employer offered you 40 hours or 1 week per the year, and you're terminated after, prior to completing that year, you're not entitled to the 40 hours, but you are entitled to a portion of that. The way you calculate that is you take the amount of hours that you were promised, divided by the time that you were promised, the time frame when you would have earned it, and that would give you a decimal point. That decimal point is going to be multiplied by the number of calendar days that you worked, and that'll give you the number of vacation hours that you were due. If your employer has a use or lose policy on vacation, that is unlawful. They are considered wages, and they are due to you, like I said, throughout the course of your employment or at separation. Next slide, please. All right, so that was my portion. I'll hand it back over to Ingrid.
Thank you, Jonathan. Yeah, we had a lot of great questions in the chat, specifically about what to do if your employer is in violation of these rules. And I'm going to leave you with that question. I'm going to leave you all with that question. We're going to cover it at the Q&A portion. But for the sake of time, I'm going to introduce Branden Butler, who we're very lucky to have. Very lucky to have both of you. Branden Butler is from the Department of Fair Employment and Housing. And he's going to be discussing your right to a safe and harassment-free working environment, free of retaliation, and how to file complaints with the Department of Fair Employment and Housing. And Branden comes with an impressive bio. He is the Assistant Director of Education and Outreach for the California Department of Fair Employment and Housing. And prior to joining DFEH in 2019, Branden was the Senior Attorney of the Fair Housing Center of the Legal Society of San Diego, where for 9 years he was instrumental in creating the first fair housing services program at LASSD that provides education, outreach, testing, and enforcement of fair housing laws. So I'm going to stop sharing my presentation, and then Branden, let me know if you have any issues sharing your presentation.
All right.
Thank you.
Thank you. All right. Well, good. I guess it's still morning. So good morning, and I'm sure y'all are getting hungry and you've been sitting, and I thought Jonathan did a real nice job and really gave you a lot of really interesting insights. I think that are always really important to get into. What I'm going to talk about is a little bit different, which is really more about discrimination in the workplace. What is it? And we'll talk about what it is and its various types, and then we'll also talk about oh, did my screen go away? Sorry.
We can see you.
I had the thing closed. Sorry. My little magnet falls off on the thing. We're going to talk about discrimination, what it is, and how to report it to us, and then I'll cover some updates in the law that I think really impact your rights. So let's jump into it. So first, I think everyone should know is that we're, if you've never heard of us, the Department of Fair Employment and Housing, we go by DFEH often, and don't be surprised if you haven't heard of us because it's kind of a confusing name, but we are California's civil rights agency. It's our job to prevent discrimination and protect the people of California from discrimination in employment, which we're going to talk about today, housing discrimination, which we cover, public accommodations, which is like business discrimination, right, at a restaurant, a movie theater, from the perpetration of acts of hate violence, right? This is where someone's being intimidated or actually violent acts committed against them on the basis of who they are. And then we have jurisdiction over human trafficking, both labor trafficking and sex trafficking on the civil side. And what we do at DFH is we do this kind of education and training for folks. But primarily how you will know us is we are the place where you will file a discrimination complaint for employment discrimination. I'll show you some slides, but we get many thousands. And so that's primarily how you may have heard of us, is we're the place where you go to file a complaint against your employer that they've discriminated against you in some way. And then we do mediation, and then where we can't resolve cases, we do file lawsuits in civil court. So I kind of walked through what we cover, but just again to reiterate, we're going to talk about the Fair Employment and Housing Act. That's the area of law that talks about that there's no discrimination or harassment allowed in the workplace. We also enforce the Equal Pay Act, as do our friends on the labor side, which is the Equal Pay Act says it prohibits an employer from paying its employees less than employees of the opposite sex or of another race or another ethnicity for substantially similar work, right? So there may not even be like an animus, right? You're not even saying, oh, I want to pay people less, but just the fact that, hey, men are getting paid blank, women are doing the same job, getting paid less. That those are the essence of an Equal Pay Act. Now there are some, defenses around that, but something to think about in terms of your rights, that you're being paid the same for others who are doing substantially similar work based on race, ethnicity. Next slide. We talk about the Unruh Civil Rights Act. That's just like out in businesses. Ralph Civil Rights Act, I will mention because it does relate to employment. Again, no one is allowed to threaten somebody with violence or intimidate them on the basis of who they are. So, some kind of, threatening someone's person or physically attacking them because they're from the AAPI community, they're Asian, or because of their sexual orientation, because of their gender, their race, all that is unlawful. We also enforce the Disabled Persons Act, just kind of providing broad access to our public ways. And then I'll mention human trafficking just because it is interesting, and a lot of what we deal with is labor trafficking. So human trafficking is not really like moving people, in a trunk. This is really about folks who are being kind of forced through kind of coercion or fraud or duress or violence, to either perform sex services or to do forced labor, to actually work and not be paid, or you can't leave, and they'll be they're threatened with their deprivation of their personal liberty. So we have jurisdiction here, and I just mentioned it because labor trafficking isn't, again, someone in chains or things like this. It's kind of broad, that someone's like not being paid, and when they ask for it, they say, hey, I'll take your passport, and you can't leave. So anyhow, and then recipients of state funding, we also say, hey, if the state is paying anyone and you're getting any money, that recipient can't discriminate, and we have jurisdiction there. So broad jurisdiction. So let's talk about employment discrimination. I think the first thing you ought to get with employment discrimination is the idea that, an employer cannot take an adverse action against you, fire you, demote you, pay you less, or harass you, either verbally or physically on the basis of one of these protected bases. So we're all protected from discrimination, but the way the law breaks it down is we break it out into protected bases. So for employment discrimination, your discrimination has to fall within one of these protected bases. If it doesn't, and it's just like, hey, we didn't get along, and I'm upset at them, and we don't like each other, that's not discrimination. It may not be fair, but that's not necessarily against the law. So what we're talking about is an employer taking an action against you because of fill in one of these protected bases. That's what we're talking about. So race, right, which can be Black, white, Latinx, it's broad, but it also includes hair texture and hairstyles. And this is kind of a new wrinkle on the law that I would mention, because there was an article recently about this in San Diego, which is, someone was facing, and I'll actually take it back to where this case came from with hair textures, which, now the law says, look, if your hair is braided in dreadlocks, cornrows, that's now considered race discrimination. If someone said that's I don't like that look, I don't want you here, that's now race discrimination. And originally this case, we actually brought a challenge many years ago where we had a Black man complainant who worked at Abercrombie & Finch, the retail store, and for his graduation from college in San Diego, he put his hair into braids. And the employer, said, hey, this isn't our surfer image. We don't like this. You got to get it out. He said no. They fired him. And the case went to our then administrative body. We used to have a group of administrative law judges who hear these cases. We don't anymore. But in that case that was heard, the judges came down and said, hey, an afro would be protected because that's natural. But if you braid your hair or you put your hair in dreadlocks, that's quote unquote not natural. So therefore it's not race discrimination as it would be with an afro. So, because of that decision, there became a move legislatively to say, hey, we need to change that to say that any kind of hairstyles historically associated with race are protected. So it would include afros, but braids, dreadlocks, cornrows, twists. So it's something to be aware of. Someone's like, hey, I'd hire you, but just get rid of the cornrows. That's race discrimination. So just be aware of that. Color gets down to the, how dark, how light skin tone is. Ancestry is similar to national origin, where someone's from, their country of origin, right? Treating people differently because they're from a different country, or I'm going to discriminate against people who are from Mexico and treat them differently. I'm not going to hire anyone from Afghanistan. I'm not, any of that is national origin discrimination. Religion, whether you have a religion or you do have a religion, you cannot be treated differently because of that. And with religion in employment, you're also entitled to religious accommodation, meaning that there's sometimes maybe a conflict in your religious practice with the practice of that of the business. And maybe there's a way you can ask for an accommodation that's not going to be an undue burden to the employer, but would allow you to still do the job. Sometimes you see this around, people say, I can't work Saturday. It's a holy day. I need to have a schedule that's different. That's a religious accommodation. They don't work Saturdays. Now sometimes if the business is only open Saturdays, then right, that could be an undue burden. And of course, you're seeing this now with vaccines, right? That people are saying, hey, I have a conflict with my religion in taking a vaccine, and I need a religious accommodation, which may be working from home, or I have to get tested every day, or it could be a lot of different things. But so anyhow, that's what that is. Age discrimination, it starts at 40 and over, right? So if you're saying it's age discrimination at 30, it doesn't count. We're talking about being treated differently because you're an older worker, not getting the right jobs, being treated, in some way you're still able to do the job, but you're being told, we're going to treat you differently because we believe you're an older worker. That's that, and you're being impacted. That's a violation. Disability, a very large area for us, whether mental or physical. Folks you can't discriminate against someone because they have a disability. I'm never going to hire them if they can do the essential functions of the job with an accommodation. That's unlawful. But also, like, denying an accommodation. What is that? Well, let's say I was working, now I have a disability, and I can still do the job functions, but with an accommodation. I may need a different desk. I may need a back brace. I may need some kind of assistive aid. But that's allowed, and so long as it's not an undue burden or a direct threat to the health and safety of others, it needs to be granted. Of course, the next one is gender and sex discrimination, right? I'll talk a little bit more about sexual harassment, but yeah, we can't treat people differently on the basis of their gender, their sex, or how they identify their gender, or how they express their gender, is all unlawful, providing broad protections from the transgender community. And then, of course, sexual orientation is protected, depending on, can't discriminate against who someone loves, essentially. Medical conditions, kind of very narrow, but you can't discriminate against someone's ongoing medical condition or genetic information, very narrow. Marital status, right? You don't want to hire the single mother with kids. It's marital status discrimination. We treat them differently. And then, of course, California, unlike our federal law, provides protections for military and veteran status. So these are protected bases. And recall, and I'll just say this, that again, it's because of one of these factors, an adverse action was taken against me. That was the dominant reason. And then remember, too, that where someone exercises their rights to file a complaint with us, or engage in a protected activity, the employer cannot retaliate against you, right? So if you do believe making complaints, hey, it was race discrimination, and the employer says that's outrageous, and I'm going to, I'm going to take away their hours. I'm going to fire them. I'm going to move them to a far remote office as punishment. That's retaliation. It's not allowed. And anyone's protected, and will protect you in that situation. And also know, even if the underlying claim of discrimination is unfounded, it's not proven in court, there was no race discrimination, but the employer still retaliated against me, there's still going to be a retaliation claim that's going to go forward. So just so be aware that a lot of times filing a complaint for discrimination and retaliation go together, but you should know, you should feel free to come forward, not only to DFH, but for internal complaints, and be assured that you will not be retaliated against. But I know it's hard, saying that and then the reality. So just a little bit about the types of cases we get at DFH. So we get a lot of cases, and we don't have our latest data up yet, but in 2019 we had 5,183 complaints filed with our office. Now, people allege more than one protected basis. So they said it was race and disability and gender, maybe all in one complaint. So that's why there's 16,528 bases of complaints. And then, not to get deep in the weeds, but some people, who believe they're victims of discrimination, they don't even want DFH to investigate the case. They want to go right to court, file a lawsuit, and you're free to do that. But you have to request a right to sue letter, an immediate right to sue letter from DFEH. That's just part of, not get too legal out, but you got to do that basically. And we give it to you right away the same day you get it. It's automatic. But of those types of cases where people have their own lawyer marching into court, there's 15,000 of those. So if you add them together, you're talking, over 20,000, kind of complaints of discrimination in California. Yeah, it's a lot of people. It's a lot going on. So it's all good to be aware of. Move through, and these are just the numbers of them. I'm going to keep rolling because we got to wrap it up at 12:15, right, Ingrid? Correct. Okay. So I'm going to just show you this slide. This is the right to sue cases we got of bases of discrimination and alleged. It just gives you an idea of what are people who are filing lawsuits. What are the bases of discrimination? And yet again, you'll see disability being the highest, as well as you see race being quite high. And I'm going to talk a little bit about family care and the family medical leave here in a second. And then here's our flow chart for a complaint. So just to break it down, if you file a complaint with our office, you have a couple options. Like I said, the first, let me see if I can activate my little laser here. So like you see here, some people just get the online immediate right to sue. Okay, they never come to us. Other people say, hey, they want to file an intake saying it was race discrimination. And then we take a look at it. We get the intake sheet. We interview the individual. And the question we ask ourselves at DFH is, do we have jurisdiction? Meaning, are they saying it's actually employment discrimination on a protected basis? Is the complaint, are you saying the date of harm was more than 3 years ago? If so, it's too late, possibly. Because you have 3 years to file a complaint with our office for discrimination. It's quite long. So you could be, do right now, it could be within 3 years of the date of harm, the date of discrimination, the adverse action. But really right here, we're just asking, do we have jurisdiction? If we do, the complaint will be filed. The employee will sign it and it'll be served on the employer. But know that we haven't taken a position in the case. We haven't investigated it. All we said was we have jurisdiction. And if we don't have jurisdiction, the case will be closed and you can appeal it. But if not, then it moves over here to this stage, investigation. Now we're actually going to look at it and interview people. At this stage, we offer voluntary mediation. If the parties want to mediate, we have professional lawyer mediators who will take it. If not, we investigate the case and then we make a determination. Does the investigation show that a violation occurred, a reasonable cause? If yes, what I call is we caused the case. Okay, now it's moving over to this track where there's going to be mandatory mediation in front of a judge. And if not, and we don't resolve the case, we'll file a lawsuit in court and then we get a judgment. So that's the flow of the case. And that process, can take some time. We need to kind of get to a resolution within 1 year of filing an employment complaint with us. So it does move, but it can take some time. I thought just kind of to wrap up some just kind of key changes as we get to 2022 that I would just let you know about. One is, and Ingrid, how many employees do y'all have?
So in the SOMAH PA, there is, I think, around 30, but I work for Grid and we have, I think, around 300.
Okay. Well, this is good then for everyone to know, which is there was a change in 2021. It's changing again a little bit, which now says in California, if you have 5 or more employees, this is where it's a change. You now have to provide job protected leave for all of your employees who need to either bond with a baby or have to take time off work to care for themselves or for that of one of their family members. And I'll define who that is. So you get 12 weeks off. If it's unpaid, you might be able to go to EDD and get, a disability or something like that. But your employer has to give you the right to take 12 weeks off, job protected, get your job back if it's what we call one of these reasons under the California Family Rights Act, or CFRA. And it changed a little bit this last year, because in the past it only applied, all the protections to employers with 50 or more. Now it comes all the way down to 5. So now small employers have to now give 12 weeks off for baby bonding, as well as for serious health conditions. What's a serious health condition? That's an illness, injury, impairment, or physical or mental condition that involves either like an overnight stay in a hospital or continuing treatment. So that's quite broad. And so that could be 12 weeks off for your own serious health condition. And like I said, before 2021, if you had to have 50 or more employees for this to kick in. Now it's 5. So basically everyone's covered. And this is different than our federal law. So, to the HR folks, you're thinking of the Family Medical Leave Act, the FMLA. This California law provides a much greater expansion, which, so just be aware of that. Now, also there used to be this rule that said you have to have 50 more employees, and you have to have 75. You have to have the employees within a 75-mile radius. Those 50. That's gone now. There's no more radius requirement. The federal law still has that. California law does it. Now it just says, hey, do you have 5 employees? And importantly, similar to the FMLA, has that employee worked at with the employer for 12 more months and has worked at least 1,250 hours in those 12 months, right? So this doesn't kick in like your second day on the job. But guess what? I'm out for 12 weeks. This is, after you've done those 1,250 hours in a 12-month period, and you've worked there for, more than 12 months, this now kicks in and you get CFRA protection. And what's new about this is I talked about you could take those 12 weeks off to care for a family member. The federal law used to say, hey, it can only be your parent, a spouse, or a dependent child. Now, under California law kind of blows that up and expands. It says, well, guess what? It's a grandchild, it's a grandparent, it's a sibling, it's a domestic partner, it's a child of any age, right? They're 50, and you got to take care of them because they have a serious health condition, 12 weeks off. And now, starting in 2022, parent-in-law will be added. So now, if you're taking care of a parent-in-law, that's now protected. You get 12 weeks off for that. So know that it's a big expansion of protected leave. You get unpaid, but you can take time off and get your job back. Also provides protections for, if someone gets family members called to military duty, active duty, you can take 12 weeks for that. Also, the law changed saying if both parents work for the same employer, it used to be the law was they had to split their time, their 12 weeks off. Now it says each parent gets 12 weeks off. And remember, it's each parent. Didn't say each married couple, right? Because you may have people at a workplace who have both parents, they have a baby, but they may not be, traditionally married, or they may even have other families. You don't know. So this can present some unique situations. This one, not just letting everyone gets protected now under CFRA. It used to be the highest paid employees didn't get this. Now they do as well. They get to 12 weeks. And also what is kind of neat for the small employers is we are now are offering mediation as part of a new law, saying if you're a small employer, since this is new to you, if someone tries to file a complaint and wants to sue you for violating this law, you will have the right to request mandatory mediation with them before they can proceed with their lawsuit. Maybe it resolves, maybe it doesn't, but that's a new right, because I think the law recognizes a lot of new employers are coming in who don't have the HR capability or professional knowledge, and there may be some violations. So that's kind of what's new. We have a toolkit if you're interested to check it out. We've got lots of information. I'll just hype this a little bit. On our website, we do have an app that I built with the UC Irvine, where if you're having a baby or adopting, fostering, or you're use this app. It's a web-based link. I'll chat it out, and it'll tell you your rights, and it's really neat. So I would encourage everyone to check it out. And let's see here. We have our sexual harassment training. I mean, just so you know, everyone in California with an employer with 5 or more employees has to take sexual harassment training once every 2 years. And I co-created this program at DFH. You can watch it. Hopefully find it informative. Employees, line staff have to do 1 hour. Supervisors have to do 2 hours. Okay, and it's every 2 years. You got to take a training. Doesn't have to be our training. You can do in-house, but it needs to be conducted. And I'll just mention real quick what's going on with COVID. may an employer require its employees to be vaccinated? Yes, the employer can require it so long as they accommodate persons with disabilities and those with sincerely held religious beliefs. So I mean, I think we kind of get that now, but there's been a lot of stuff in the paper that's allowed. And if someone objects to getting a vaccine because they don't think it's safe and they don't want to work here, can the employee discipline them? Yes. If the employee requires you to show proof of COVID-19, can they ask for that? Yeah, you can ask you to submit your card, show proof of vaccination. So that's pretty much the deal on COVID right now. They don't have to, but if they do, then they can, and you have to require it. I'll kind of leave it there because I was just going to get into. Let me just lastly mention this because I think this is important, which is we've done a lot of work around the Fair Chance Act. What's that? The Fair Chance Act basically says employers have to give people who are formerly incarcerated a fair chance to get a job, meaning that you don't just have a rule saying that you don't ask about a criminal conviction until after you make a job offer. That's the bottom line. Shouldn't be on an application, shouldn't be asked in the interview. It's something after you're offered the job, then the employer can say, hey, we're going to run a background check. You have been convicted. But they can't look into arrests. They can't look into cases that were dismissed, et cetera. So just know that there are rights. If you're formerly incarcerated and you get a promotion and you're being denied that, this law would apply to you. The employer has to take certain steps. And we've created a whole toolkit for you with videos and forums, really more for employers, but I have videos and toolkits for you. And the rest, I was just going to roll through cases we've done, but I want to leave time for questions. Correct, Ingrid? So I'll pause here and stop sharing, and we can get to those questions.
Thank you. Yeah, our first question is around meal and rest breaks. We have an employee whose employer has them work during their shift. So what kind of options does that employer have? How can he file a complaint with DIR? If you can speak to that, Jonathan.
Oh yeah, thank you. Is this the one made by Salvador Betancourt?
Yeah.
Okay, so I was looking at the questions. So basically, if your employer is prohibiting you from taking your meal break, there's two things. The employer has to pay you the premium wage, which is 1 hour for the meal, 1 hour for the rest. I know you said that if you take lunch, they give you attitude. That's not really against the law. It's only against the law if they prohibit you from taking the meal break, or if they otherwise reprimand you for taking that. So, but attitude, it's not necessary. It's not how the law reads. You also asked regarding you tested positive for COVID. If I read all your messages, you also stated that you have a month and a half working for the company. So supplemental paid sick leave, which was also known as COVID pay, expired September 30th of this year. So unfortunately, you would not qualify for any payment under the supplemental paid sick leave. There is California paid sick leave, which you can use in lieu of the supplemental paid sick leave, but you have to be employed with the company for at least 90 days in order for you to be eligible to start using your California paid sick leave. So based on the information you provided, I don't see that you qualify to use anything at this time, unfortunately.
Thank you for that clarification, Jonathan. One follow-up question is, if let's say hypothetically, because I actually want to know too. Let's say hypothetically this employee works through his lunch. Takes his lunch, and then subsequently a couple days, weeks later is fired. What can he do? How can he file a complaint?
If he believes that he was fired because of exercising a right, which taking a meal period is your right to do so, he can file a retaliation claim with our office. So referencing back to the website that I showed everyone, there's different claims that you can file. One of them is a wage claim. One of them is a retaliation claim. And then there's a couple other ones, but generally filing a retaliation claim will, trigger an investigation on that issue.
And that's on your website.
Yes,
right?
yes.
Yeah. Okay, thank you for that. We have another one around duty-free unpaid rest periods, but I need more clarification on that question. Jamie Carrington, can you go off mute and explain your question?
Sorry, there's two people logged into my my name. It's me, which is Julie, and then the other one is Jamie. Can you unmute her instead?
Yes, just did.
Hi, thank you. Thank you, Julie. I'm sorry, I tried to identify in the box that I was a guest of Julie, and that was a question for me. So this probably sounds kind of weird, but just for clarification, as a speaker, thank you very much for speaking. He talked about the duty-free rest periods, unpaid, and the like. And I've always had this question, and I used an example in my Q&A, if one was to start, working at 8 and end at 4, in the day at 4, that's 8 hours. Is one to reduce the paid hours? And I thought it was all inclusive of duty-free periods and breaks, which amount to, at least a minimum of 50 hours. I mean, 2 10-minute breaks and 1 30-minute break. Is the employer required to reduce the pay hours by 50 minutes, or is it all, are the duty-free breaks paid or unpaid?
Okay, so in your scenario, you're at the place of work for exactly 8 hours. So taking a 30-minute unpaid meal break, technically your employer is only required to pay you for 7.5 hours. The 30-minute meal period is unpaid. The 2 10-minute rest breaks, those have to be paid. So in your scenario, you're technically only working 7.5 hours. You're only entitled to 7.5 hours of pay.
Thank you. That was that's always been an issue, and you just brought it to light here. And I thought I've always misunderstood that meal breaks were paid by the employer. So thank you.
So the only time when your meal period should be paid is if you're working through the meal period. So obviously you would be paid to that. A lot of times this is more common when your employer has like a required luncheon. Okay, we're gonna bring in lunch. We're gonna have a quick training while everybody has lunch. Technically, you're under the control of the employer, so they have to pay you for that time. And because they did not afford you a 30-minute duty-free meal period, now they would be required to pay you 1 additional hour, which would be the premium for failing to provide you the meal period.
Thank you.
Thank you. Yeah, Stacy, can you mute? Okay, got it. And then Julie I'm not sure if it's Julie or Jamie, could be either one, had a question about, are working lunches legal? Working lunches being in a meeting during lunch breaks, pre-COVID, food provided. I'm assuming this is like they're working, maybe it's a staff meeting and they're working through that lunch.
I mean, technically it is in violation of the meal period, but as long as they're paying the premium, they've rectified that violation. Not legal, but it's easy to correct.
Thank you. And I think that's all the questions that we have.
Ingrid, I actually have a quick question for the two speakers. What does the timeline and process look like for folks who are filing claims to each of your departments or entities? How long does it take to get an answer or an action taken? And what can someone expect?
So as far as filing a wage claim through our office, so I'm located in the Bakersfield office. So the timelines I'm going to give you are just specifically to Bakersfield. I know other offices are more concentrated areas, so the time frames vary quite a bit. But if somebody were to go in today and file a wage claim in our office, right now, estimated time for the initial conference, which is a form of mediation, you're looking at somewhere around 8 to 10 weeks, roughly. So at the mediation, if there is no resolution, then and we have established that we do have jurisdiction to address those issues, then we refer it over to a formal hearing. And formal hearing from the conference is about another 8 to 12 months for the hearing. Could be less, but that's general timeline. And then depending on the complexity of the case, that could delay it even more. So there's some cases that they've been delayed quite a bit because we're waiting on decisions from Supreme Court. We're waiting on our legal unit for guidance. So it really depends on the complexity.
Okay. For DFEH, for a employment discrimination case, we, statutorily need to get it done within a year. So it could take up to that time. Sometimes we can get both parties to agree to give us more time to investigate, kind of what we call equitable tolling. But generally, for employment discrimination cases, we got to get in there within. It needs to be done either within a year. We've charged the case for moving forward or not. And so that's our time frame for running a case through.
I had a question for both of you. Can any of you either chat the link now or just email it to me later, but chat the link of like the forms that people need to fill out to file a claim, or like an FAQ of the process, if you have that.
Yeah, I can chat it out. Yeah, I mean, our website, here, we have a whole overflow of the complaint process, and then there you can file a complaint online through our CCRS system. So if you do have to file a complaint, you can just do it all right there or call us. So here's the link.
Thank you. And we have another question from Erica. What would you say to someone who is worried about how much bringing a case will cost them financially and how much time they'll have to take off work to be involved with the case?
Well, from the DFEH standpoint, I mean, there's no charge, of course. We represent the interests of the state of California, and so when someone brings a complaint, we often kind of are working with them in their interest. They usually have their own lawyer, and they have whatever they're doing, an agreement worked out on what'll be the pay. But if you don't have a lawyer, you don't need a lawyer. You just file a complaint and take your case with us. So you don't need anything there. In terms of time off, I mean, it depends, but you're probably looking at depositions, and obviously if a case goes to trial, needing to be there. But that's very rare that a case is going to trial. I mean, usually it's probably going to be taking time off to do your interviews with the investigator, doing the mediation. Let's say both parties do voluntary mediation. Now a lot of that's being done on Zoom, but in the old days that would be like an 8 hours in an office, so to speak. And then after that, it's wherever it goes. But most cases get resolved in that settlement. So the cases that are going all the way, more rare. So I wouldn't want anyone to feel that filing a complaint is going to overburden you. You should feel free to file it. It's don't be afraid, and certainly don't let a financial limitation stop you, because it's not going to cost you anything. And if you lose and it doesn't happen, then you don't pay anything either. It's not like it's if you lose, you pay the other side. No, that's not the way it works.
I've heard concerns about someone's reputation, that these cases are public record. So if someone files a discrimination case later on when they seek employment, that their employers are going to look at them as liability because they're, litigious. So can you speak to that and how, prevalent that is, or if it is a concern, a legitimate concern?
One, they'd have to be really digging, because if you just file a complaint with DFEH, you'd have to file a Public Records Request Act. And then if the case is closed, you could maybe get some of it, but we redact a lot of the confidential data. So, you'd have to be hiring a team of detectives and things probably to find a DFEH complaint. Now, if you file a lawsuit and it's, that is a little more public, maybe, if it, is a large case, you'd find out, but, pretty rare, I think. So I don't think folks, need to be worried. But, there are a lot of rules now around, when people do sign settlements, that the complainant, the employee has the right to speak about this, right? There's new rules around non-disclosure agreements. Those are, new year, you can't do it anymore. Say, hey, don't talk about this for any claim under FEHA. So it's usually more like the employee wants the right to speak about what really happened, and the employer is usually trying to say, don't talk about it, keep it quiet. So it's, so I don't know how like public it gets from to your point, but I think actually in some ways it's the publicity might be in favor of the complainant because they're trying to protect, they were discriminated against and there was a resolution. Look what happened. So yeah, I think folks shouldn't feel like it's going to be a scarlet letter or anything. No.
Jonathan, can you speak to that concern as well? Like,
I fully agree with Branden. I think our agencies are, working pretty much exactly with the same, same processes. With regards to costs, it really used to be more on just showing up to conferences, hearings. Now with Zoom, I mean, we've been holding hearings and conferences for the past year and a half, and it's still ongoing. So I would definitely encourage you to file a claim if you feel like you need to address something, because we do, we can definitely work around your situation if you're unable to appear in person. So
great point via Zoom, Jonathan. I mean, that's true. It's really increased access. It used to be you drive 3 hours here, 4 hours there for mediation that may not result in anything. So it's really hopefully a new avenue for folks to enforce their rights. Yeah,
definitely. We had a case where an individual flew from Maine for mediation, and we were shocked. You could have just called and we would have definitely accommodated you, because the travel, you cannot you're not gonna be able to request the compensation for your travel expenses. I mean, just the travel alone was more than the actual wage claim. So in situations where it's definitely something you can consider a barrier, we can work around that. So don't get discouraged and filing because of that. So we can definitely assist with that. As far as the the aspect of potentially having your name out there as you're the one that filed a complaint against the defendant or an employer, it's very similar to the FEH. We have they would really have to be digging. They would have to file a Public Records Act request. And again, there are laws that protect that. Why would an employer be very, specifically looking into someone that much? So it would take a lot of digging for anybody to really, bring something up like that. And I agree, it's mainly the employee that wants to, let people know, hey, this employer did this to me. I want everybody to know. I want everybody to stand up and know your rights, enforce your rights, and go through whatever process you need to make in order for for somebody to make it right.
Good point.
Good point. Yeah, thank you. And we have another question in the chat, but before we get to that question, I want to ask if people have follow-up questions, can they email you? And if so, can I chat your email addresses on here?
Okay. I'm going to put the email address where they can send in their questions, mainly because this is the general. Actually, sorry, I think I just did it to the panelist.
Okay, I can rechat it right now. But yeah, we had another question from Salvador. It seems like he was expecting a call back from the employer to return to work, and he never received a call. So I guess there's a couple things going on. Like, I don't know if you can speak to that, but it seems like my sense is that, he's maybe I'm reading into this too much, but maybe he's concerned that he's not going to get called back ever. And is he being terminated for being sick? And what can you do about that case? And if I'm misinterpreting, please help me out. So,
I mean, something that we tell folks that come into our office regarding employment is California is considered at-will employment, meaning that the employer does not have to hire you, just the same way that you don't have to work for that employer. The situation with Salvador may be a little more complicated because of the time that he's been employed. If he's only been a month and a half, the protections are going to be very limited or maybe non-existent. So that itself creates, some issues. So.
Yeah, and I would just say it's hard for either of us really to opine on someone's individual, case or something, so, but yeah, I hear you, and Jonathan laid it out right. Well, I enjoyed it. Thanks a lot, everyone. Thank you, Jonathan. Hopefully we can connect offline too. I'd love to check in with you, see how we can collaborate.
Yeah, definitely.
Thank you all so much. I'm gonna send an email out with your guys's contact information and some like a one-pager of how they can file claims or just information on these topics and the recording. Thank you all so much, and thanks for joining today. This will be recorded and uploaded onto our SOMAH website, and yeah, please tune in for more webinars like these. Thanks again. Take care, everyone.
Bye.